The breaking news story right now out of the Supreme Court of the United States. Will, what's up?
So we got the opinion this morning from the court, and the short version of what they found is this. Comes from the opinion from Chief Justice Roberts. Fulfilling our role, we hold that the IEEPA, which is International Emergency Economic Powers Act, does not authorize the president to impose tariffs. And because of that, it is Congress's role only to levy taxes. Therefore, because it doesn't explicitly say it, this broad interpretation will not stand, and we overturn the tariffs.
Saying that their rules on tariffs, overall, this will be considered a loss. Now, there are some nuances to it.
But here's the concern, Cliff, that Justice Kavanaugh brought. One is that he says in his dissent, the sole legal question here is whether under IEEPA, tariffs are means to, quote, regulate importation. The statutory text, history, and precedent demonstrate the answer is clearly yes. Like quotas and embargoes, tariffs are traditional and common tool to regulate importation. And he goes on to even draw the analogy, of which the chief pushed back and did not agree with, but that the predecessor to this law was Trading with the Enemy Act. And in 1971, President Nixon imposed a 10% tariff on almost all foreign imports. So the president, using the predecessor to this law, Richard Nixon, did basically a blanket tariff of 10%. That was upheld by the Supreme Court in the 70s. Now, this is a new law that kind of replaced that Trading with the Enemy Act, which had different language, but kind of kept the same core language when it came to this. That's where Justice Kavanaugh is saying, look, Congress didn't specifically then ban the tariff portion, of which was upheld by this court. And then he also goes on to say, this is going to create a mess, by the way, because there's a bunch of other statutes that allow the president to impose tariffs.
Right.
So he goes on to say, and I think this is a fascinating statement, is that he says, basically, in essence, the court today concludes that the president checked the wrong statutory box by relying on IEEPA rather than another statute to impose tariffs. So the court didn't even say the president can never impose tariffs.
They just said maybe he filed it incorrectly.
Exactly, that maybe using IEEPA, which was a quicker way to do it than some of these other statutes, that they're just saying under IEEPA, no tariffs. Justice Kavanaugh had a big problem with that.
He brought the wrong document to the DMV, trying to get that real ID, and that's what happens, okay? You know, it sometimes takes you a few times.
Part of the problem that Justice Kavanaugh brought up is that based off of the ruling, the president has the power to regulate the trade. He could shut off the entirety of foreign imports.
Yeah, just say we're no longer importing anything. Now, obviously, that would destroy our economy.
Here's the direct quote. As they interpret the statute, meaning the majority, the president could, for example, block all imports from China, but cannot order even a $1 tariff on goods imported from China. So that goes back to the point of it. If you then put the president in a corner and say, hey, you can't do the tariffs, then this president is going to find ways to push back on the things that he sees are harming the economy, such as the trade deficit. So could he start blocking trade with countries? Yes, he could. And I think even under the way the Supreme Court ruled on this, they would say, yeah, you're allowed to do that under this law. You just aren't allowed to use a tariff.
Okay, what does it mean for the tariffs right now? Like, as of today, are they done? Do they not exist? Where are we now with those tariffs? Including, by the way, some of you who are in small business who have maybe had some concerns with the tariffs.
The tariffs that were imposed under IEEPA are the lower court is upheld that blocked them. So therefore, they are going to no longer be in effect.
And in theory, that would be...
But here's another problem.
Immediately?
Here's another problem. So the government's no longer going to be collecting the tariffs, but they've collected billions of dollars of tariffs. One thing the court didn't address, and it is remanded back to a lower court, so maybe we will see something out of a lower court of how to address this, but the Supreme Court didn't address how to handle the money that they're now saying was collected improperly.
Don't give me any ideas.
Which are billions of dollars. And even Kavanaugh points to that, saying that this is going to be a situation because we don't even say how it says the refund process is likely to be a mess. And how is that going to play out at this point? We don't know at this stage of the game.
And the Supreme Court got a little nuanced, as we said. It's not necessarily as cut and dry as it maybe appeared. And they certainly wanted to make it feel that it was maybe a bit more bipartisan. And with that, there were some references within the opinion that Will pointed out that we think you're going to find pretty interesting.
This is from the opinion written by the chief. And when he lays out very much a textualist argument about the power to tax, the power to impose, which once again, I know a lot of you are having deja vu from Obamacare, but even though he created a tax in that instance and upheld it, this was saying it's a tax, and so therefore I am overturning it. As he goes through this rationale, this is on page 7, talking about not reading too much into vague language to grant another branch of government's power to the other branch unless it's explicitly said. And this is very interesting. And I think this is why, even if you disagree with the ruling, you need to think that the judicial philosophy of some of the justices that ruled in this way, you can't just write off. Because a lot of times, if they're using this same philosophy, they're going to rule with you. And so I want to read this. It says, "We have long expressed reluctance to reading into ambiguous statutory text extraordinary delegations of Congress's powers." And he cites West Virginia versus the EPA. In Biden versus Nebraska, for example, this was from 2023, "We decline to read authorization to waive or modify statutory or regulatory provisions applicable to financial assistance programs as a delegation of power to cancel $430 billion in student loan debt." In West Virginia v. the EPA, "We decline to read authorization to determine the best system for emissions reduction as a delegation of power to force a nationwide transition away from the use of coal." So the chief here is showing that we're not making any claim about the policy. We here, me writing as the opinion of the court, is saying this is a textualist argument where, and I have done the same, this court has done the same when it came to Biden canceling $430 billion in student loan debt and the way that the EPA was trying to use a vague wording in a law to force America away from coal. Those are two things that are initiatives and rulings that conservatives were very happy with because the court saw that the executive branch was overstepping and relying on vague language. Now, I tend to agree more with the history and the way that Justice Kavanaugh laid it out, but I think that you can't take this as an unserious anti-Trump move the way that the ideological reasoning came forward.